Meyiwa's longtime friend, Slindelo Madlala, continues his testimony this morning in the trial of 5 men accused of killing the soccer star. Madlala was in the house when Meyiwa was shot back in October of 2014. eNCA reporter Slindelo Masikane joins us now to just not only give us context but also to anticipate what's to be expected today. Slee, good morning to you. Perhaps let's start with that context from yesterday. What did Slindelo Madlala have to say in court?
Good morning, Dumelo. Yes, of course, it's day 2 of Slindelo Madlala's testimony here in the North Gauteng High Court. This is one of the people who was in the home when Meyiwa was shot and killed back on the 26th of October 2014. And of course, he's one of those witnesses that has been anticipated. And South Africans and of course the Meyiwa family who have flown up to Gauteng to watch proceedings this week are also very much interested in what he has to say. But to give us some more context and analysis on his first day in court, I'm joined by legal expert once more, that is Mr. Marius du Toit. Thank you very much once more for your time this morning. Maybe let's just start with the drama that occurred outside of court with the media. Of course, the judge quite unhappy with what happened with the witness before he took to the witness box, and in fact banning the TV broadcasters, the journalists in particular, as well as visuals for the first half of proceedings. I understand this was, of course, a move to possibly just stamp his authority in terms of Judge Maumela over the proceedings.
Yes, Slindelo, I think firstly we have to remember that the judge is in charge of the proceedings, and the court, because he's in control of the proceedings, it's his duty to ensure that the decorum of the court is maintained, and of course that the proceedings run smoothly, and that when there is in fact TV coverage, that it's the least possibly invasive method of reporting to the public out there. And the moment it encroaches upon the ability of a witness to voluntarily go to the witness box and testify, well then of course the court could intervene. And I think you're right by saying that the judge tried to stamp his authority. I think from the other side, we of course have to say, with the progression made with courts having or being accessible to the media, is of course fantastic for the public out there who's simply not able to be there, and with reporters like yourself, you know, giving us literally a blow-by-blow event of what's going on there, gives us the opportunity of actually being spectators in court. So one must never negate and even diminish the effect and the effectiveness of media, but it must always be done in such a way that it, at the end of the day, does not encroach upon the free running of the court.
Let's move to the testimony now, Mr. du Toit, of Slindelo Madlala. He's being led in terms of his evidence in chief by the state, and on at least 2 occasions the court proceedings had to be adjourned to allow for him to compose himself. In fact, the other adjournment was an early postponement for the trial overnight because he was getting quite emotional in court. Will there be any inferences made in terms of his demeanor in court?
You know, I think, Slindelo, the reality is that we as dispassionate, objective viewers of a trial can easily, you know, say that the matter is unemotional. However, when you are a witness to a murder, it's not only traumatic, but it's something that can traumatize you, and you can even suffer from post-traumatic stress as a result of it. So I think the courts are sensitive to the fact that when we deal with murders or when we deal with events like this, that you could have witnesses really feeling the gravity of the event once they testify. And of course the court takes that into consideration. But you can't say because a witness is emotional, now suddenly the witness is lying, or you can't jump to the conclusion to say because he's emotional, he's truthful. It's just a factor that the court will take cognizance of to say, well, listen, we had to adjourn a number of occasions to provide this witness the opportunity of gathering himself. But you can't really read anything into that other than to say, well, maybe this witness was just traumatized with what he viewed. Maybe he kept it within himself all this time. And now suddenly that he has the opportunity of speaking in a forum where not only the media, but the public at large is looking at him, suddenly the gravity of the event is maybe striking, and that's why we see some emotion. So there's nothing that can truly be read into the fact that the witness is emotional, other than these events are not staged. We are dealing here with real events of a real murder, and to many people witnessing that, that's extremely traumatic.
We anticipate, Mr. Du Toit, that cross-examination may begin today, possibly after tea, depending on how long it takes the state to lead this evidence in chief. What can we expect from the defense in terms of what they're going to try and poke holes in terms of Dumelo Madlala's story?
So when any witness gives evidence, direct evidence about the event of this nature, there's a number of things that the state would want to look at. Number one, they must ask themselves, are we calling this witness purely to give context to the events of this day? Or are we calling this witness to identify one of the accused, maybe identify his clothing, maybe put very distinguishing features on record of the accused, or maybe just give context to the events itself? And whatever the context is that the state seeks to gain from this evidence will determine the cross-examination. If this witness comes forward and says, listen, I saw a person wearing a red shirt and brown pants, for argument's sake, and he was 6'1" and he was about 180 pounds. The reality is, if any of the accused match that sort of description, you might want as an attorney to maybe touch on that. However, if your client was not identified, if this witness never went to an ID parade, never identified one of the accused, then you need not go much further than just stating that, listen, you didn't identify my client will say it was never there. And then it's up to the state to prove. So in many respects, when you call witnesses like this that aren't really able to identify one of the accused, it's more to give context as to the events. It's more to give context as to maybe what happened to the spent cartridge. Maybe this person will say, well, listen, when the shot was discharged, I saw the cartridge being flung around, the room, or maybe in the corner. And maybe we can now say, well, listen, this cartridge was in fact there. So the state would, I would think, at the very least, try and give context to the events of this day. It's obviously that this witness is an important witness, but he might not be the witness putting the accused at the crime scene. And for that reason, it will dictate the type of cross-examination that we can expect. If this witness comes forward and suddenly identifies one of the accused as the perpetrator, well, then that advocate or attorney has a duty to, of course, put in context and say, well, sir, it's the first time that you saw this person. You never attended an ID parade. The only reason why you pointed this person today is because he's before court. Because you now know one of these 5 people might be involved in this killing, and that's why you're pointing them. And then you would go to the characteristics, you'll go to the identity, you'll go to the clothing worn on this day, and you can try and negate it or poke holes into his observation. Because often you would try and say that, listen, so your observation skills were not that good. You didn't pay attention to this, to that, or any of the other things. And as a result, I don't think you were so observant, and I don't think the court can really rely on your identification. So seen in isolation, it will depend on what exactly the state wishes to gain from this witness, and we'll only then be able to say, well, listen, what we can expect from the defense.
Thank you so much for your time this morning. Once more, that is Mr. Marius Du Toit, a legal expert, just unpacking day one of Dumelo Madlala's testimony here in the North Gauteng High Court. Of course, proceedings resume at 10 a.m. this morning. We will be bringing you those visuals live.